Hello.
Hi.
I want to ask you some questions about foot impressions, okay?
Okay.
I believe, is it okay if I show you the animal or
Whatever you want to do, either way. Just give me a heads up on numbers.
number 67?
Okay.
So I want to ask you some questions about the foot impressions in Exhibit 67, okay?
Okay.
That's the marker number 1 at the scene on the muddy road, is that right?
Yes.
And marker number 2 at the scene on the muddy road, is that right?
Yes.
Those are visible on the screen right now, is that correct?
Yes.
And those foot impressions are in what appear to be tire tracks.
Yes.
There's here on exhibit (283). Have you seen this before?
Yes.
And you see here on the side, there's the brown, the muddy road. Is that right?
Yes.
And there's a label for the footpath. Is that right?
Yes.
The photos that you have of the footpath are just those two markers there, 1 and 2. Is that correct?
There's more photos of the path that are marked with individual yellow flags, but those are the only impressions that were marked with a number designation.
Okay. And so the only markers that we have, we know for sure, are in the tire path, correct?
They are on the road, right? That looks like there are some other impressions visible.
Marker number 1 is a foot impression, right?
Yes.
That's in a tire path, agreed?
I would have to look at the photo closer to agree or disagree if that is actually in a tire impression.
Handing you a copy, so you have one in your hand. Marker number 1 shows a foot impression in the tire path, agreed?
Sir, I can't agree or disagree whether I think that's in a tire impression.
Your answer is you don't know?
I can't tell from this photograph.
Okay. And same question for foot impression number 2 that we see up on the screen. That impression is in the tire track. Agreed?
The impression is in the mud. I can't agree or disagree whether that's a tire track or if I would consider that to be a tire track.
Do you see a track in that photo?
I see a lot of impressions, but I don't see an individual tire track per se.
You don't see a line from left to right going from foot impression 2 to foot impression 1 where there's an indentation in the mud that appears to be a tire track?
I see a lot of impressions above markers 1 and 2 and a line of impressions, but I can't really confirm if that is the edge of a tire impression or if that is created from an impression that 1 and 2 are lying within. I just simply wouldn't feel comfortable making that statement either way.
Okay. On that same photo, at the top of the photo, do you see a similar indentation from left to right across the screen?
Similar compared to what?
Do you see this ridge that I'm pointing to on with the red pointer?
I do see the ridge.
On the other side of that ridge, there seems to be an indentation.
There does.
That indentation that I'm pointing to at the top of the photo appears to be parallel with the markers 2 and 1 in this indentation right here. Agreed?
They do appear to be running parallel, yes.
And they appear to be at about car width length apart.
I can't tell that without a scale within the photograph.
Okay. You would agree that tire impression in mud would be a smoother surface than the rest of the muddy road. Agreed?
Can you repeat that question?
You would agree that a place on a muddy road where a tire drove across and left an impression would make that part of the muddy road smoother than where the tire had not ridden across.
I believe it would create an impression. I don't know if it would necessarily be smoother than the remaining portions of the road.
Okay. And you don't have any photos here that you've taken or that you saw at the scene that would show impressions other than marker 1 and 2?
There were numerous overall photographs taken of the scene that documented the road, the trail of foot impressions that would show impressions that were present, and no more additional close-up images.
These are the only close-ups you have?
I would have to look through the photos again to confirm that.
Okay. You were asked some questions about whether you observed other impressions at other places on the muddy road. Is that right?
Yes.
You were there at what time at night?
9:30 p.m. through 6 a.m. the following morning.
Fair to say that the sun is down during those hours?
Yes, it was.
That you were never there at the scene when the sun was up?
That is correct.
And you were asked questions about what observations you made there that night in the dark. Is that right?
Yes.
And you'd said there that night when you were in the dark, you were not able to make observations of other impressions of a body, a face, a knee, an arm, a hand in the muddy road. Is that right?
I did not notice any other impressions of that nature along that road, but I did walk the distance of that road numerous times to get supplies.
Sure.
And was assessing the road and what may or may not be present as far as evidence related to this scene.
And you agree that at times somebody could have been walking in the grass,
Yes.
and the grass portion in that area was more solid surface?
Yes.
And if something had happened, there was no footpath in the grass. Agreed?
Correct.
Even of just a foot impression. Agreed?
It would be difficult to find.
And it'd be
Right.
difficult to find if somebody fell in that harder surface in the grass and leave an impression for you to observe there that night in the dark.
Correct.
All right. So just the fact that you didn't see it doesn't mean it didn't happen. Agreed?
That's correct.
All right. I want to ask you some questions about collection and swabbing, okay?
Okay.
You'd said that there's two different ways that you can test eventually for DNA evidence. Is that right?
Yes.
There's one way to test. There's two ways to gather the evidence to do the testing.
Yes.
And one is for you to take a swab at the scene. Is that right?
Yes.
And another is for you to collect the item itself, bring it back to the lab, and give it to the DNA technicians to do that, correct?
Yes.
So I don't want to ask you about the collection in that part. I want to ask you about the swabbing portion.
Okay.
On the swabbing portion, you grab a cotton swab, right?
Yes.
And then you make a decision about where to place that swab, right?
Yes.
It's discretionary.
Yes.
And it, you see a brown stain and you rub the cotton swab across that brown stain.
Yes.
Sometimes it's very particular, right?
Particular in what
In
fashion?
a position and where you swab.
Correct. It could be based on what I feel is an area that should be swabbed is up to my discretion. Yes.
And then sometimes it's a wider area that you swab, correct?
Yes.
So depending upon what you see and what you decide, you could swab a area as small as a dime-sized area,
Potentially, yes.
or you could swab an area 3 inches by 3 inches.
It would be depending on what I'm trying to locate. I typically don't swab areas that large.
Okay, what's the largest area that you swab?
I can't recall.
Okay, and in this case, you don't recall in particular how large of an area you swabbed when you were looking at marker 13 on the side of the trailer,
That's correct.
or marker 14 on the side of the trailer,
Correct.
or the markers inside of the vehicle,
Correct.
or marker 2 that's on the rear driver's side door on the frame of the door in the driver's side, correct? We can show you a photo of that here.
Sure.
I can find it. Exhibit 96. You able to see marker 2 there?
Yes,
And the area to, as we're looking at the photo, to the right or to the rear of the vehicle is the area that you swabbed, is that right?
yes,
And you're not able to tell us today the specific position that you swabbed, correct?
correct. I wouldn't be able to tell you where within that entire stain I specifically swabbed because we don't document that.
Okay. And you would agree with me that you could swab in one space and get one DNA result, and an inch over get a different DNA result. You would agree?
That seems unlikely unless it were a sample of a mixture. When you sample or swab a stain within a scene, you're looking at areas that kind of like patterns or stain areas or locations, and then you swab and it's representative of that area. So if I would have seen additional stains within that stain, I would have perhaps pursued swabbing in a different fashion than a stain that appears to just be maybe a transfer stain across that surface. I would have no reason to believe there'd be additional reasons to swab from numerous locations within that stain.
But in answer to my question, you would agree that in certain situations, the DNA could differ from one position to another position as small as an inch away.
That could be a possibility, yes.
Okay. You talked about transfer, is that right?
Yes,
And so this exhibit that we're talking about in particular, you use the term transfer, is that right?
yes, I did.
Because that does not appear to be a drip, is that right?
That is correct.
It appears to be, my layperson's term, a smear of blood perhaps from clothing?
I will say that I am not an expert in blood stain pattern
We probably shouldn't get
analysis,
into
so I don't want to make conclusions regarding the types of stains. However, I am trained to recognize basic patterns within a scene.
And you used the term transfer there,
I
correct?
did, yes.
Why did you use that term?
It's because it's a very light stain that appears to have just been brushed across the surface of that vehicle.
Okay, and what you're saying is you don't know what item, whether it was a person or a clothing or something else that did the brushing, so to speak.
Correct. I have no way of knowing that.
Okay. Exhibit number 97. Okay, we look at that. I'm going to ask you some questions about the photo on the marker 3 on the back of the trunk. You see that?
Yes,
And that's the back of the trunk, is that right?
yes,
And you would agree that does not look the same as a transfer on marker number 2, agreed?
correct.
All right, and so you took a swabbing of this marker as well, correct?
Yes, I did.
And you were talking about previously that you'd seen foot impressions at the rear of the vehicle?
Yes,
You weren't clear whether the impressions were of a foot or footwear, if I recall, is that right?
that is correct.
You just saw impressions somewhere in the rear of the vehicle.
Yes,
You don't know, as we sit here today, you have no memory of where they were in relation to the rear of the vehicle.
to the rear of the vehicle and to, I'd have to look at a directionality closer to the driveway that is marked on the sketch.
So the passenger, closer to the passenger side of the vehicle.
Yes,
And marker number 3, you would agree, is on the passenger side of the rear vehicle.
it is toward the passenger side of the vehicle, yes.
And in relation to the foot impression, footwear impression that you observe but you don't have a particular memory of today, you're saying it's behind the vehicle. When I say directly, it's somewhere within the behind the vehicle. It's not off to the side at an angle. Agreed?
It was not directly behind the vehicle, but there was a lot of activity within that, impressions in the soil or the mud at the rear of the vehicle and off to the side.
Okay.
Yep.
More than one?
Yeah.
Okay.
Yep.
And that's near the trunk area, is that right?
To the trunk and towards the passenger side, yes.
All right. Could I see Exhibit 95? Marker number 1, there was on the rear passenger door, there was this stain that you observed, is that right?
Yes.
And that appears to be a drip?
A heavy concentration of blood.
Correct. And
Yes.
it's going from top to bottom as gravity would dictate?
I can't tell the directionality of
Can we
that.
see Exhibit 94? You would agree now, looking at Exhibit 94, that it goes from top to bottom in a manner consistent with how gravity would affect a liquid?
It is a line, a stain that's in a line
Yep.
pattern.
Going from top to bottom? Yes?
I can't really see where, if it would be an assumption to say that that would be from top to bottom.
Okay. So you're saying it could have been from bottom to top?
It could have been.
Okay.
Yeah.
You agree gravity works from top to bottom?
I do, yes.
Okay. And I didn't mean to be a smart aleck there. You're trying to be very precise with your words, and I appreciate that. Is that fair?
Yeah,
Okay. And so whether it's top to bottom or bottom to top, it's up and down, right?
yes.
Okay. I want to ask you some questions about the shoes, okay? If I could see Exhibit 75. The shoes were Exhibit 237 and 238 that we saw here in person when you pulled them out of the bag. Is that right?
Are you referring to the shoes from the scene or from inside of the vehicle?
The Nike shoes from inside of the vehicle you pulled out of a bag here, and it was marked Exhibits 237 and 238.
Yes,
The black ones, right? The
yes,
sneakers.
yes.
Okay. I want to ask you questions about those. All right?
Okay,
They were found in the back seat of the car. Is that right?
yes,
Underneath a coat.
yes,
And on top of the coat was Mr. Woodworth's body.
yes,
Okay. This impression here at marker number 5 is outside of the driver side rear door. Is that right?
yes,
And if we look at Exhibit 285, there's a circle I'm pointing here called E5, is that right?
yes,
And that's the same evidence marker 5 that we see up on the screen, is that right?
yes,
And that's pointing to, if I follow that arrow, the position right outside of the door, correct?
yes,
Again, you photographed that, correct?
yes.
And you're not able to take a cast of it because that's just outside of the ability of your lab.
A cast of that impression
Yes.
could have been collected.
Could have
Yes.
been collected.
Yes, it could.
Okay. And so you chose not to do so.
That is correct.
All right. A discretionary choice that you make on the scene.
Yes.
Okay. The, if I could see exhibits 100, 101, and 102, I think in that order. That's a photo of the shoe that was found in the rear footwell behind behind the driver's seat in the vehicle, correct?
Yes.
And as you mentioned, on that photo, you observed a presumptive, well, maybe a brown or a red-brown smear on the inner portion of that bottom sole.
Yes.
Did you do a presumptive test for that?
I would need to refer to my notes to see if I did or not.
Okay, do you have those notes with you?
Yes, I do.
Do you have them up there with you?
Yes.
Go ahead. Does that refresh your memory?
Yes, it does.
Did you do a presumptive test of that reddish-brown stain on the bottom of that shoe?
No, I did not.
Okay. If we go back to, apologize here, Exhibit 75, marker number 5, there appears to be a reddish-brown stain in that photo. Agreed?
Yes, there is.
Did you take a swabbing of that reddish-brown stain there?
No, I did not.
Okay. You talked about not knowing about the order of the impressions or imprints in the ground. Is that right?
Right.
But you would agree with me that what we see would be the last impression. Agreed? If somebody had stepped over that, it would have disrupted that, disturbed that, not left it in that condition. Agreed?
That would be possible if someone stepped directly on top of the impression at marker 5, then that would have been disturbed.
Because the reason that there's an impression left is the ground is soft, right?
Yes, it was.
And so if, assuming it's someone around the same time and the ground was still of the same consistency, a person stepping on top of that would have left another impression over the top of that. Can we agree on that?
That would be very likely, yes.
Okay, and so what we can agree on, this would be the last impression into that soft portion of the ground, right?
Into that portion of the ground, yes.
Okay. And were you able to determine a directionality of that impression? Where's the front of the shoe impression, and where's the heel of the shoe impression?
There are additional photographs of that impression with a scale that would show the directionality that I would want to refer to
Refresh
speak
your
to that, yes.
And is your memory as you sit here now that the direction was towards the rear seat of that car?
I would want to refer to my notes before I made that statement.
Okay. I'm going to come back to that. We'll have somebody find that photo. Okay. Exhibit 101. And then that's the bottom of the same shoe that we previously looked at on Exhibit 100, correct?
I believe so. I just don't have the exhibit numbers memorized.
Sure,
So.
I appreciate that. And then Exhibit 102, 100 and 101 appear to be the same shoe, is that right?
Yes.
That's 102, which is the right shoe. And then we can go back to 101, which is the bottom of the left shoe.
Yes.
And then 100 is the bottom of the same left shoe with the angle that shows, can you go to 100, sir? Thank you. Which shows the reddish brown stain that there was not a presumptive test taken on, right?
Correct.
So as we're sitting here in this trial, we're not going to be able to know if that is blood and if it is somebody in particular's blood, correct?
Unless it went through further testing at a later date
Okay.
after collection.
Okay. But if my memory serves me correct, you didn't do a swabbing of that at all, did you?
The item was physically collected in its entirety, so if further testing was needed, it could have been swabbed for analysis.
Okay, and that would have been something then, since it's no longer at the scene, it would have been something that somebody like Kevin Scott would do?
Who's,
know?
who's Kevin Scott, the DNA analyst? I'm sorry.
That's
I
fine.
forget. Yes, a DNA analyst would perform those tasks.
Okay, all right. But as you sit here, you don't know whether or not there's any way to tell that today, correct?
Correct.
All right. I'm going to put on a screen the picture of Exhibit 616. Does that appear to be the same foot impression by marker number 5 that we were previously discussing?
Yes, that is the impression at marker 5.
And that has the ruler that you were mentioning, is that right?
Yes.
And then, let me do this. I've got 3 photos. I'm going to come up and show them to you, and you tell me which one you want to chat about. We'll put that one on the screen. How's that sound? Is there one that's better for you to look at than another?
No, I don't have a preference.
Okay. Let's just chat about the one we'd already put up there, Exhibit 616. Based upon this exhibit, are you then able to refresh your memory as to the direction of that impression in relation to the open rear car door?
So you can see at the bottom of the scale, the arrow pointing north. North is towards the road.
Yes.
So the impression is either going towards or away from the vehicle. I'm not a footwear examiner, so I can't really conclude in what direction that impression is being. I wouldn't feel comfortable making
Okay.
that statement, but it is either going towards or away from the vehicle.
Just because I'm north orientated, I'm going to turn this around, and now north is to the top on the screen. Do we see that?
Yes.
Same photo, right?
Yes.
Correct. If that's north, to the left of that photo would be to the west, is that right?
Left would be west.
Okay,
Yes.
I screw that up all the time, so, and to the right would be east,
Yes.
to the bottom would be south.
Yes.
Okay, and so we can agree that on the left side of this photo, the shoe appears to be wider than on the right side of the photo. Can you agree to that?
I do agree with that. Yes.
Okay. And on Exhibit 285, north would be to the top of this, is that correct?
Yes.
All right, and so, can I go stand underneath there? Can I go stand behind the rail here, Judge?
Go ahead.
So both this photo and this are both to the north now, is that right? You see that?
Yes.
Okay. And so, help orientate me here. The impression we're talking about is here where my finger points. Is that right?
Yes.
North is that way.
Yes.
And then this is getting to the west. Is that correct?
Yes.
On the car is on the west side of the trailer. The
Yes.
trailer is on the east side of the car.
Yes.
Okay, thank you. Questions about, I believe it is the back seat. Is that Exhibit 107 there? So, yes?
Yes.
Thank you. So on Exhibit 107 showing marker 8, that was presumptive blood on marker 8 and marker 9, is that right?
Yes.
And then on Exhibit 109, that's markers 10, 11, and 17, is that correct?
Yes.
And those are also presumptive blood, right?
Yes.
Then on marker 112, or excuse me, Exhibit 112, those are markers 12, 13, and if I recall from memory, 18,
Yes.
and those are presumptive blood as well, correct?
Yes.
And then on exhibit number 118, That is a marker I can't see with my old eyes. 21 and 22 perhaps? Do you agree?
Yes.
And those are also presumptive blood.
Yes.
And so on all those last 4 photos that we saw, the reddish brown stains that we see in the entrance to the back seat of the vehicle and then the back seat are presumptive blood. Is that right?
Yes.
And then here on this photo, we see where this white strip is a defect in the rear seat. Is that right?
Yes.
And you would agree with me that that appears to be somewhere in the middle area of the rear seat. Is that right?
Yes.
Okay.
Yes, it is.
The door that we see that's closed, that's the passenger side door.
Yes.
The perspective is we're looking in from the driver's side.
Yes.
And this defect, you don't know when or how that got there, correct?
Correct.
You just know that there's you called it a tear, I believe.
Yes.
Okay. And then if we could see, I believe, Exhibit 112 again. Again, there's another defect on the rear of that seat, is that right?
Yes.
And that's again something you called a tear.
Yes.
You don't know how that got there.
No, I do not.
But fair to say that both this tear and the other tear are consistent with being punctured by a knife.
I can't make that statement.
You can't rule that out. Agreed?
That's correct.
Yes. Then I want to ask you some questions about the presumptive blood at the scene on the ground, okay?
Okay.
I believe on Exhibit 72, thank you, we see, this is again the scene there, correct?
Yes, it is.
And at marker number 9, that's presumptive blood, agreed?
It appeared consistent with blood, however, I did not do presumptive blood testing on the scene.
Okay. Number 9, you took a sample of it?
Yes.
And then at some point, did you test it with this, what was the fancy test that you called?
The phenolphthalein. is the
Phenolphthalein.
test.
Did you do that?
I did not. That could be a function that is performed within the DNA unit.
Okay, because you didn't take a swab there, you collected the grass, that was something for the people at the next step down the line. Would that be fair?
Yes.
Okay. And 10 and 11 are the cigarette butts.
Yes.
Okay. 3 and 4 are the boots.
Yes.
And then as we see up at the top there, that's number 12 where my red dot is, correct?
Yes.
And again, you took a sample of that, correct?
Yes, I did.
You can't say whether it's presumptive blood because you just took the sample and passed it down the line.
Yes.
All right. And then number 81. Here again, this is the scene where we see number 11, which is the cigarette butt.
Yes.
Number 6, which is the navy blue blanket.
Yes.
And then again, we see number 12, which is up past the driver's door near the trailer. Is that right?
Yes.
And then on the side of the trailer is number marker 13, correct?
Yes.
And you did do a presumptive, you took a swab of that, correct?
I collected a swab, yes.
And you did a presumptive blood test for that?
No, I did not.
Okay. And then here where my pointer is, that's number 14. Agreed?
Yes.
And you took a swab of that?
Yes, I did.
And again, did you do a presumptive test on that or not?
No, I did not.
All right. And then number 83. This is again a close-up of marker 12 where you took the sample.
Yes.
And then number 14. Agreed?
Yes.
And all of those are again documented on Exhibit 285, which is labeling where they are according to their numbers. Is that right?
Yes.
You'd agree with me that E14, E12, and E15 are all south of the open car door.
E12, 14, and 15?
12? So
Yes, they would be, the door would be open and those would be south of the corridor. Yes, I would agree with that.
all right. And then if we can go to the next one, I believe that's 88 is, that's 15.
Yes.
Which is, again, you took a sample of that reddish brown stain, agreed?
Yes.
And obviously that's, we can see where that is in relation to the car because we see the front driver's side tire stuck in the mud, right?
Yes.
And it's, again, pointed out here on the Exhibit 285, exactly where that is, south of the open driver door.
Yes.
All right. So there's appears, if we can go back to 72. It appears as if there's reddish brown stains on both sides of that open car door, to the north, as well as number 12 to the south, and 15, which we can't even see here because it's up forward in the dark. Agreed?
Yes.
On both sides of that doorway, there's reddish brown stains.
Yes.
Okay. Exhibit 76, I want to ask you about the blue blanket. We see the marker there of 6, that's to indicate the blanket, is that right?
Yes.
This, where I'm parked on the ground, is eventually, well, that's different than 9, apologize. Is there a sample taken of the reddish brown stain under the blanket?
No.
The blanket itself was collected.
Yes, it was.
And the blanket itself, you have no knowledge whether the blanket itself was ever tested in some way for DNA. Agreed?
Right. I don't know.
Okay. Exhibit 6A, the cardigan, I want to ask you about that. I believe that was, well, we can see it right there in that photo, can't we? I want to ask you about the, what you call the cardigan that you pulled out of the bag earlier, okay?
Okay.
We can see that in the photo there, correct?
Yes.
And you'd pulled that cardigan out of what bag was it? I want to make sure I get this right. Exhibit 207. Sound about right?
Yes.
And the cardigan that you showed us had buttons on it.
Yes.
And it had no tears. Agreed?
I did not see any tears just looking in the room with everybody.
And it was there at the scene, correct?
It was.
When you were there, Ms. McCandless was not there. Agreed?
That's correct.
You don't have information as to what Ms. McCandless was or was not wearing when she arrived at the farmer's house, do you?
No, I don't have that
When she
information.
arrived at the hospital?
No, I don't.
Are you aware of what, if any, other clothing what, if any, clothing Ms. McCandless had that was sent to the crime lab? Do you know?
I know clothing was submitted to the laboratory. However, that wasn't anything that I handled.
Okay, have you seen pictures of that clothing?
I have seen pictures, yeah.
Okay. Showing you what's been marked as 619, do you recognize the item in that photo?
I have seen that photo before, yes.
So you do recognize it?
Yes, I do.
Okay. So the item in Exhibit 619, you would agree is not the item that we see up in that exhibit, correct?
Correct.
This is, item 619 is a photo of a different gold sweater. Agreed?
That looks different, yes.
Permission to publish?
No objection.
All right.
May,
So again, this photo here, marked as Exhibit 619, is different from that's a photo of a sweater that's different than the photo that you pulled out of the bag that was at the scene, right?
Correct.
Okay. And are you aware whether either the photo, if we could switch back to the PowerPoint, whether that cardigan that's in that photo there, which is Exhibit 76, whether that cardigan was tested?
I don't know that answer.
And do you have any knowledge as to whether the sweater in 619, whether that was tested?
I don't know.
I want to ask you some questions about the coat, all right?
Okay.
That was in Exhibit 236 that you pulled out of the bag, the big black coat, is that right?
Yes.
Had about 3, 4, 5 bags that you had to dig it out of, right?
Mm-hmm.
That was in the car, is that right?
Yes, it was.
Yeah, picture 72, Exhibit 72. You would agree it was not on Mr. Woodworth's person, agreed?
Agreed.
As we can see in Exhibit 72 and as well as 84 and 85, he was not wearing that photo, or he was not wearing the photo. He was not wearing that coat. Agreed?
He was not.
All right. The coat is, in this photo, you can't see it, but you know based upon later knowledge that the coat is underneath his body.
Yes, it is.
All right. So that's another picture. He's on top of the coat in that position. Is that agreed?
Yes.
And then on Exhibit 87, I believe, is where we then see the coat in that footwell. Is that right?
Yes.
And the coat, as when you held it up, were you able to make observations of the defects to the back of the coat?
I did see defects, yes.
Okay. I think I asked you this, but just to be sure, we agree he wasn't wearing it, it's on the ground.
It's right, it's on the floor of the vehicle.
And underneath the coat are his shoes,
Yes.
or at least a pair of Nike shoes that we've previously talked about, right?
Right, the Nike shoes.
And those, so we agree the Nike shoes were not on his feet, correct?
Correct.
In the pictures that we'd seen previously, we saw that he was not wearing shoes. Agreed?
Agreed.
And you would agree that the foot impression at marker number 5 was of a shoe rather than a foot. Agreed?
It was a shoe. It was a shoe impression, or there was the tread was visible. Yes.
Okay. All right. I want to ask you some questions about the hair that was found there, okay?
Okay.
There was you said, a clump of brown hair found on top of the coat that we've just been discussing. Is that right?
Yes, there was.
And that's shown there in exhibit number 99, correct?
Yes.
And the sticker number 4 is actually for the coat. Is that correct?
4, and then I sub-designated with the A, so that it is pointing to the hair as 4A.
Okay. I did not catch the A, so thank you for the clarification. So the coat is 4, and then the hair is 4A.
Yes.
All right. And then on number 98, did you see another? That's showing just number 4 without the A, which is designated for the coat. Is that right?
Correct.
Okay, thank you. And then on exhibits 104 and 106, that's a clump of hair in the rear driver's side footwell, agreed?
Yes.
And so that would have been underneath the black coat that we've just been talking about, correct?
Yes, it would have been.
And either underneath or next to the Nike shoes that we were talking about.
Yeah, in that vicinity. Yes.
Okay. And there's marker number 7 there, and that's to indicate that particular clump of hair.
Yes, it is.
So we have 2 clumps of hair, one clump designated as 4A,
Yes.
and one clump designated as 7.
Yes.
And you collected both of those clumps and passed them down the line for somebody else to do DNA testing.
Yes.
All right. Do you have exhibit, is that 106? And so that's another picture, exhibit 106, that's a picture of the rear passenger, or the rear seat, correct?
Yes, it is.
And we see there on the footwell, just at the bottom here, sticker number 7, is that right?
Yes.
And so it's in that vicinity where the second clump of hair was that you found and collected, is that right?
Yes.
Okay. Now, in this photo, you agree that there's no hat on the back of the driver's seat, is that right?
That's correct.
There was a hat there, correct?
I don't recall seeing a hat.
You were not asked any questions in your direct exam about a hat, correct?
I was not.
Showing you what's been marked as Exhibit 620, 621, and 622. Are those photographs taken by Ms. Laxton at the crime scene, or at the crime lab?
Yes, State Exhibit 621, 622, and 620 were all photos that Brooke took.
You're familiar with those photos?
Yes.
They accurately represent the car as it was received at your lab, correct?
Yes, they do.
Move for the admissions of 622, or 21, excuse me, 620, 621, and 622.
Any objection? No. All right, Exhibit 620, 621, and 622 will be admitted.
Permission to publish via the Elmo.
Yes, you may.
Exhibit 620 is a photo of the rear of the vehicle, is that correct?
Yes.
And in it we can see the...
Council, what image number is that? Just so that I have it.
Sure. 31, 620 is image 31, 621 is image 33, and 622 is image 34.
Okay, thank you.
You're welcome. So back to Exhibit 620, that's the back of the driver's seat, is that right?
It is.
And that appears to be a hat that is halfway on that rear of that driver's seat, is that correct?
Yes.
And at one of the pictures I believe you have of the, of the trunk, contents of the trunk, there showed the hat, is that right? Or was the contents of the rear of the vehicle, I believe?
I would have to look at the photos to see if it was collected with the contents from the rear or the front.
Sure. Found it, thank you. Showing you what's been marked as Exhibit 433. That's been previously admitted. Is that a photo of the contents of the rear of the vehicle?
Yes, it is.
And in that photo, we can see the hat. Is that correct?
That looks like the hat, yes.
Winter hat without a little bop on the top, correct?
I don't remember much about the hat, and I didn't collect it as an item of evidence, so I don't know if it had a top or not.
Okay. So no testing of that hat. But here in Exhibit 620, we see that it was partially on the back seat. Is that right?
Yes, I do see that.
And then on Exhibit 621, in the upper portion of that, we can see again the hat on the back of the headrest. Is that right?
Yes.
And then from the other angle here on Exhibit 622, we can see the hat halfway on the headrest. Is that right?
Yeah.
You don't know how that hat got to be in that position that you see it here in the photos, do you?
No, I do not.
You don't know how it got to be just partially on the back of the headrest, correct?
Correct.
Whether it was fully on before and got taken off in some sort of struggle or not, you don't know.
No, I don't know that.
But we know that it's partially on in that photo.
Correct.
You talked about concerns about contamination as part of your investigation, is that right?
Yes.
And that's because something as small and tiny as DNA can sometimes be transferred from one person to another person into a place, is that right?
Yes.
It could be transferred, that's why you wear the gloves, to make sure that if you touch the coat and then you later touch the sweater, you're not transferring something from the coat to the sweater. Agreed?
Yes, that's correct.
And it's the same thing because people can sometimes transfer, like you at this, if they're not wearing gloves and you're out at the scene, you can transfer DNA from one place to another, agreed?
Yes.
So it's very important in your line of work to make sure that you're not contaminating items of evidence, right?
That is correct.
That's like rule number one in your world.
Yes.
The most important rule, correct?
Very important, yes.
Okay. You were at the scene and you saw the pillow that was collected at the scene, is that right? Was there a pillow?
There was a pillow.
And the pillow it's marked in exhibit number 285, is that right?
The pillow is documented in the sketch, however, it was not collected as an item of evidence.
And when you say it was not collected, what do you mean by that? You left it at the scene?
It was placed into the vehicle,
Okay.
and it was documented as being in the vehicle when it came to the lab, and it was not collected. I did not consider it a piece of evidence or collect it for further testing.
Well, what somebody at the scene did is they picked up that pillow, correct?
Yes,
And they took the pillow and they put it inside the car.
that is correct.
And they put it on another piece of evidence inside the car, correct?
Yes,
That pillow could have contaminated what other pieces of evidence it was touching. Agreed?
that's a possibility, yeah.
I mean, essentially, that's a breaking of one of the cardinal rules in your world, right?
The pillow I believe I placed the pillow in the vehicle so that we didn't leave a item of evidence at a scene, as well as some deer antlers that were outside. I didn't view it as contaminating the vehicle or any of the items within inside of that vehicle.
But you agree that there was a pillow at the scene?
There was a pillow.
Despite what you previously said, you did collect it, correct?
It was placed in the vehicle, submitted to the laboratory, and then returned to the agency with the vehicle.
Showing you what's been marked as Exhibit 631. Is this a picture? Can I do it this way, or do I need to go through that way?
That's fine.
This is a picture of the pillow, Exhibit 631. Is that right?
That is, yes.
And this is a picture of the pillow that you took from the ground at the scene and placed on top of the painting. Is that right?
Yes.
And that's exhibit number 624, correct?
Yes.
There's nothing separating the pillow from the painting, is there?
No, there's not.
So that would be breaking protocol within your world, correct?
If the pillow itself contained blood, then yes, that would. But there was no blood visible on that pillow.
Okay. You didn't test the pillow, did you?
No, I did not.
You didn't take any collections from the pillow, correct?
No.
And other than blood, there's other ways for DNA to get on items, correct?
That's correct.
DNA is invisible to the human eye.
Right.
So whether there was DNA on that pillow or not, you can't say based upon your observations, correct?
That's correct.
The better practice would certainly not to put the pillow on the painting. Agreed?
Not ideal. I'll agree with that.
Whether it did or it didn't contaminate it, you don't know, correct?
That's correct.
But that's exactly why you have the policies and procedures that you do, is because you can just never know, right?
Yeah.
That's all. Thanks.
That's it for cross?
Yes, sir.
Okay, Mr. Hahn, any redirect?
Just briefly, there were some questions, Ms. Hoffmeyer, about the lighting, the fact that you were there in the dark. Is there supplemental lighting brought into a scene when you're processing something in the middle of the night?
Yeah, occasionally additional lights will be brought in. We have lights, a lot of different lighting fixtures that we carry on the crime scene response vehicle that we can bring out to the scene, and we have a lot of really good flashlights.
Did you feel like you were hindered by darkness when you were processing this crime scene?
No, I did not.
There was a question or a line of questioning about the possibility of different DNA being contained in the same single stain.
Correct.
Did you see anything about the stains that were sampled in this processing of the vehicle that would have indicated that there was any reason to believe there were multiple sources of DNA?
It's something that I can't know from just looking at a stain, but as I described before, you select areas of stains that are present and you believe that those are representative of the stains in that location. And if I felt like there was a need to document more, I would have definitely done that.
You're a supervisor at the crime lab. We've established that, correct?
Yes, I am.
Are you familiar with submission guidelines?
I am, yes.
If you could explain for the jury what submission guidelines are.
The laboratory has submission guidelines for the evidence that they will or will not accept for testing. And each discipline at the laboratory has their own set of submission guidelines that they follow.
For different types of cases, are there exceptions where more items of evidence will be received for analysis than other types of cases?
The laboratory will put a priority on homicide investigations and will typically accept more items of evidence for those types of crimes.
If you're aware, was that emphasis or that exception followed in this case?
If it's pertaining to the items that were submitted for DNA analysis, I don't oversee that unit, so I'm not sure what exceptions would have been made for this case.
Those submission guidelines, while there may be exceptions made, are there, even if it's a homicide case, are there still limitations on the number of items that will be received at the crime lab?
Yes, there are limits on the numbers of items they will receive per submission.
Nothing further, thank you.
All right, any recross?
While there's limits on the number of items that may be submitted per submission, you would agree that there is not a limit on the number of submissions, correct?
Can you repeat that sentence?
You just testified and told the jury that there's limits on the number of items that can be submitted to get tested per submission. I believe that was your testimony.
Per submission, yes.
But you agree that there is no limit on how many times submissions are made. Agreed?
A lot of that is handled on a case-by-case basis based on the needs that are expressed from the law enforcement agency and the attorneys on what is needed for that case. So I'm not sure if there would be a limit. There will be a time when the lab just cannot continue to test items.
Sure. But that is, there's nothing written in the policy to say you can only make 3 submissions or 5 submissions or 10 submissions. Agreed?
Not that I'm aware of, right?
It's a case-by-case analysis, correct?
Yes,
It's discretionary.
yes.
And the agency that is submitting it gets to make a pitch to say, here's why this is important, correct?
Yes, they would express the need for the investigation, yes.
And then your lab or somebody at your lab would make decisions on whether they would be persuaded to then do additional testing on that additional submission. Agreed?
They would make that determination, yes.
So you would agree, essentially, there's no limit to the amount of items that could be tested, right?
I don't agree with no limit because we can't we can't test thousands of items of evidence due to the resources that we have within the laboratory. So there is a limit that would be reached at some point, but it's handled on a case-by-case situation.
Okay. So the limit would be something less than 1,000.
Much less than 1,000, yes.
Okay, but probably upwards. I'm sure you've had cases in which there's more than 100 items.
Yeah, yes.
It wasn't this case, though.
I don't know exactly how many items were tested within this case.
That's all.
Nothing.
Okay. All right. Thank you, Ms. Hoffmeyer. You may step down, and I imagine you're free to leave.
Yes.
Judge, just to make sure we don't need her, I forgot to move to admit the exhibits that I had referenced and put up on the Elmo. So we can do that without Ms. Hoffmeyer.
I think so.
All right.
All right.
So I've been released from my subpoena?
Yes.
I believe so.
Okay.
You're good to go. Thank you. All right. I'm not sure how many photographs you had, but 620, 621, and 622 were received.
I made a bit of a mess, so if I can come up here and try to sort it out. I believe
You made reference to 616.
621, 622. And 620, 21, and 22 were the hat, which I would move for admission of.
Yeah, 620, 21, 22 there have been received.
619, the sweater.
Any objection?
No.
State. All right. 619 will be received.
616.
616, 617, and 618, the pictures of the foot impression with the ruler near it.
What, 616 through 618?
Judge,
Yes.
I believe just 616 ended up being the one used. It was placed on the Elmo and then presented to the witness, and she was allowed to pick which one, and there was only one selected of the three, I believe, that was used.
That's fine. I think they're all the same, but I'd move for all three, but I understand their objection.
All right, so you're offering 616?
Yes.
Okay, 616 will be received. Is there any objection to the others?
No.
They're all the same, but,
No.
so if you prefer, that's fine. 616, 617, and 618 will be received.
And then I believe I made reference to 631, the pillow. Move for the admission of that.
Any objection?
No.
Okay, 631 will be received.
And then, to be honest, I don't recall exactly which photo of these I used and unused one. And then 624, the pillow on the painting.
Any objection?
No.
624 will be received.
That was it, Judge. Thank you.
Okay. All right. I think we'll take a short recess, just a brief restroom break. You stay ready with other witnesses?
Yep, Judge, I think we might need a little bit longer, just have an evidentiary ruling or two we want to do before we start testimony.
Okay, so we'll start with the break, and hopefully we'll keep it as short as possible. Okay, all rise. I understand the next witness you anticipate is Ms. Wobler from the crime lab, or not? No?
She's unavailable today, so
Okay.
you're going to call Samantha Cobes.
Okay, and what are the issues that should be addressed before we bring the jury back in?
Your Honor, the first is the state wants to introduce as an exhibit, it's a phone download regarding text messages between Alex and Ms. Cobes. And so there's only one text message that the state intends to introduce, and it's made from February 25th of 2018, where Alex sends Ms. Cobes a message stating Jason found out and had a fit at Racy's. Ezra got stressed out and blew up at me for not talking about my past. Woke up to a text asking me to forget her name and not talk to her again. The state believes this is occurred right after the kind of Jason Mingle confrontation on February 24th at Racy's, where he confronts both Alex and John Hansen. And so I believe it falls under the statement of recent perception exception under 908.045 sub 2. It's a statement not in response to any litigation, which narrates, describes, or explains an event or condition recently perceived by the declarant, Alex, made in good faith, not in contemplation of pending or anticipated litigation, and while the declarant's recollection was clear.
All right, and you're offering it, I take it, for the truth of the matter in the message itself?
Yes.
And what about confrontation issues?
Well, I believe it's an exception because,
Well, it's an exception to the hearsay rule, but...
yeah, and it's not testimonial either.
But, okay, so you believe it's not testimonial, that it's a deeply rooted hearsay exception?
Yes, Your Honor.
Okay, Mr. Nelson? Okay,
Please, since I just found out about this like a minute ago,
sure.
and I just found out what hearsay exception the state is planning to go under. By the way, statement, not that it matters, but statement of perception is not considered firmly rooted, I don't believe.
It's not considered what?
Firmly rooted.
Can I respond to that?
Well, why don't we do Ms. Fishney?
But
Oh, okay, I'm
Great.
sorry.
I
thought
don't
you
think
was done.
firmly rooted is even relevant anymore. But
Well, I think it's, I guess it goes to whether it's testimonial or not.
well, I don't think the statement's testimonial, so I'm not objecting on confrontation grounds. I'm objecting
Okay.
on hearsay grounds.
All right.
Okay. Well, first of all, prior to the hearsay grounds, let me just say that the state has to clear an authentication hurdle. And I don't think that this witness can authenticate that this text came from Alex. She received a text on her phone. How does she authenticate that it is in fact Alex Woodworth who made the statement? I think the state should address that because that's a condition precedent even before we address the hearsay issue. Statements have to be authenticated to be admissible, including text messages. And so how is that matter going to actually be authenticated that it came from Alex Woodworth to Samantha? Has she gone and looked at his phone and looked at the original of the text messages? Just because a text message came from Alex's phone is not sufficient to authenticate it as having been made by Alex Woodworth. She apparently was not there. I don't know if the state is going to proffer that she had a subsequent conversation about Alex where he stated he had told her about this text. But they have to prove more than just throwing in a text message and saying she can testify about it under a hearsay exception. So before we even get to hearsay, I would like to know what the state's basis for authentication is.
All right, well, I guess I'll throw it back to the state.
Thank you, Your Honor.
And Your Honor, first of all, that goes to weight of admissibility. But if the witness looks at the other messages in the download, Ms. Koobs was planning on moving or having Alex move in with her. And so the messages before and after that both talk about making arrangements for that download, or excuse me, for that move to happen. And so the other messages before and after also provide context to the witness.
All right, well, again, until I hear what all of that is, I guess I don't know, but I think a witness with a familiarity with somebody in the context of conversations they were having by text message, I think that would be a reasonable basis for authentication of a message. You can certainly cross-examine. I mean, I guess the possibility exists that somebody was pretending to be Alex Woodworth on the other end of that. But really, in the context of all of this, is that how realistic is that? So the court would be satisfied that the witness, based upon the circumstances, if she was a party to a number of conversations and text messages, that would be sufficient to authenticate the message. And again, you can certainly make that argument. I mean, if that is ultimately an issue in this case as to whether somebody was pretending to be Alex Woodworth, texting on the other end, but now let's get to the hearsay exception.
Well, since the state is the proponent of the evidence, I think they have some duty to explain why they think it fits within this exception and what the case law is.
And, Your Honor, we did brief this in our state's response to defendant's motion in limine to exclude hearsay, where we went through the number of these exceptions. Statement of recent perception was one of the exceptions the state outlined, as well as cited a number of cases. So I would direct the defense to that brief if they want more. I think I cited to State versus Balos 230 with second 2 at 507. I cited State versus Weed 263 with second at 434.
Well, let me just say this. I know what the Balos case is off the top of my head. That's about a 911 call in a domestic violence case. And basically, State versus Balos stood for the proposition that it really didn't, even though it was a pre-Crawford case, that it really didn't violate the right to confrontation, and that a statement of a domestic violence victim made in a 911 call was an excited utterance exception. So it kind of preceded the United States Supreme Court rulings very much in I think it's Washington versus Davis v. Washington, and Hammond versus Indiana. I'm sorry, I'm going off the top of my head, Judge. The statement of recent perception is different than the exceptions that are cited by the state. And the lead case on it is State v. Manuel, which is State v. Manuel, Manuel. I believe that is the lead case, which is cited at 275 with second 146, or the version I'm using is at 2004 Wisconsin Appellate 111. And in State v. Manuel, so first of all, it does require the declarant be unavailable, which is the case here. Furthermore, State v. Manuel said with regard to this, they held that it was a non-testimonial statement, which I concede this is a non-testimonial statement. And basically what happened in Manuel was this, and I'm just going to read the overview from the case. After a man flagged down a car, the defendant walked up to the vehicle and shot.
Slow down just a little bit.
Yeah, sorry. I'm bad when I argue. A defendant walked up to the vehicle and shot the driver in the neck. All right? The man who flagged down the car made a statement to his girlfriend that the defendant had shot the victim. The trial court admitted the statement into evidence. And the defense argued that wasn't permissible. So it was very much like a present sense impression, but the declarant was unavailable. And there was no other reasonable inference that the man's statement was anything other than a spontaneous comment to his girlfriend, motivated by his need to explain why he wished to take her and their son to a motel for a few days because of this violent incident that had been witnessed. And the circumstances surrounding the statement rendered it sufficiently reliable to admit it, and that cross-examining the person would be what the court said was of marginal utility. That's factually really different. I mean, the way the state wants to use statement of recent perception is to virtually admit any hearsay statement made by any person at any time, or in the context of this trial, made by Alex Woodworth at any time to any person. That's not what the rules allow for. It has to be an actual statement of recent perception. So what Alex is texting his friend on February 25th at some point in the morning, because it says that this is in UTC time, -6. So at the 1:09:40 p.m. is in Wisconsin time or UTC time? That's a little unclear to me. But what he's telling his friend, or what precedes this conversation, is he's basically telling his friend that he and Ezra broke up. And she's asking what happened, and he says, Jason found out and had a fit at Gracie's. Ezra got stressed out and blew up at me for not talking about my past. Woke up to a text asking me to forget her name and not talk to her again. So this part of this statement that he makes to his friend Sam are events that occurred the previous evening. He's telling her basically that last night Jason found out and had a fit, and Ezra was stressed out and then blew up at him for not talking about his past. So those are events from the night before that he's discussing. Those are not statements of recent perception. They're nothing like the events in State versus Manuel. Now, the next part of this is that he woke up to a text asking me to forget her name and not to talk to her again. We understand that that text message in and of itself, the actual text, not Alex's discussion about it, but the actual text will be admissible in court because it is a statement of a party opponent, because it's a statement of Ezra McCandless, and they're going to be able to authenticate it. But Alex's state of mind about what she had done in terms of the text, that he woke up to it, how is that relevant to this trial that he's telling this to his friend? Or even that he's telling his friend that Jason had a fit the night before, or that Ezra was upset about something because he hadn't talked about his past. So we first, even before we reach the hearsay issue, how does that tend to prove or disprove a fact of consequence in this particular trial? How does the fact that he communicates to his friend about waking up to this text tend to prove anything? I agree the text itself can come in. But, so I'm objecting, I'm adding a relevancy grounds and a hearsay grounds because these are not proper statements of recent perception.
Okay, State, why not?
Yes, Your Honor, if I could, if the court would take a look at State versus Weed, W-E-E-D, 263 West 2nd, 434, 2003 WI 85. That's a 2003 decision of the Wisconsin Supreme Court.
I'm sorry, counsel, the site is 263 with second what?
Anna, can you?
Wisconsin 2nd, 434, 2003 WI 85. In State versus Weed, 3 days before the homicide in that case, an individual made a statement, the victim made a statement to another individual saying he had unloaded the gun that ended up being used in the homicide. The court found that that statement made 3 days earlier was a statement of recent perception under the statute. 3 days, not the day before as we have here, but 3 days before. The court said, and I quote from Weed, and this is at paragraph 14. The circuit court admitted the hearsay statement under the recent perception exception to the hearsay rule. The exception for a statement of recent perception under WISSTAT section 908.045 sub 2 requires that 1, the statement was not made in response to the instigation of a person engaged in investigating, litigating, or settling a claim, and was made in good faith with no contemplation of pending or anticipated litigation in which the declarant would be an interested party. 2, the statement narrated, described, or explained an event or condition recently perceived by the declarant, and again, in that case, 3 days earlier was found to be recently perceived. And 3, the statement was made while the declarant's recollection is clear. There is no question in this case, Your Honor, under the definition and the factors set out in Weed at paragraph 14 that this is a statement of recent perception. It relates to an event that occurred the night before, the day before, and an event that occurred that morning. Clearly, those are matters of recent perception. There's no question that they are made while the information is clear in his mind because he's very clearly describing what happened. And there's no question that at the time that these are made, this communication is made, this text is sent on February 25th at approximately 1:09:40 p.m. That's the time in Central, at that time it will be Standard Time, which is UTC time -6. That it was not made in contemplation of any pending or anticipated litigation. Obviously, Alex Woodworth could not be anticipating that a little less than a month later that the defendant would murder him, and that therefore it's important that this information get out. It's relevant because it shows Alex's knowledge that in fact the defendant had terminated their relationship, and is relevant to show that he knew that. And it's relevant towards later on, we'll hear testimony from other witnesses that Alex honored that termination, that he did not initiate communications between himself and the defendant, that the defendant then chose to initiate communication with him on March 22nd, but that Alex understood the relationship was over, and that's when he understood it was over at that point in time. And so it's relevant for that purpose. So for all those reasons, Your Honor, it should be admissible. Thank you.
Well, Judge, I want to say the following. I do believe that the state has accurately summarized the Weed case, though the more recent case on this is State versus Manuel. I don't think there's a per se time limit is like a statement of recent perception, which really, a statement of recent perception really has to kind of happen right there. Excited utterances require the stress. This exception doesn't. But it seems to me that the focus, when I look at the language in Manuel, has to do with the reliability of the statement. So, the question is partly, is Alex's statement, is there a degree of reliability and a lack of self-interest in this statement that about what happened the previous night at Racy's? I mean, we have an engagement of these different people who are in some rather intense emotional relationships. So I would argue that the portion of the text regarding that really does not bear that indicia of reliability that the portion of the text where he said he woke up to a message from Ezra saying she didn't want to see him anymore. That, in my opinion, does bear some indicia of reliability, and I can see the state's argument for that, but the other half of this doesn't. But regardless, we still have the whole question of why is his state of mind on February 25th about what happened the night before, or his statements, how are they relevant to this trial? I don't understand the state's theory of admissibility, so I think the state should explain that and see perhaps if I'm missing something.
Well, okay, I'm ready to rule on this. The court's going to allow the statement. I believe, first of all, the declarant is unavailable, fits within a hearsay exception. It's not testimonial, and it appears to the court. In the Manuel case that you're talking about, present sense impression, it's a different hearsay exception that was involved. This is a statement of recent perception. The court believes that it's sufficiently recent, and also that for those other reasons, it is not in response to any investigation or a claim, and it does narrate or describe a recent event. As to relevancy, I think it goes to the panorama of the evidence, the context of the relationship between Ms. McCandless and Mr. Woodworth, Mr. Mangle, and all of those circumstances. It's part of the overall puzzle of what has occurred in this case. The court believes it is relevant, so we'll allow that through this witness, again, assuming that the authentication is sufficient. Mr. Nelson?
Judge, I understand Your Honor's ruling under 90107, rule of completeness. We'd ask that the previous 5 text messages also come in. The conversation begins at timestamp 1, message 30, in which Alex says, things just went really bad between us, and I don't think she is going to be in town again. And then Sam says, oh fuck, what happened? And then he responds with the message that we're talking about. So I think from the rule of completeness standpoint, I think those previous messages in which Alex begins by saying, things just went really bad between us, and I don't think she's going to be in town again, would also then be admissible.
All right, well, does the state have any objection to that? I certainly,
No.
okay, the court believes that the entire thread there for the rule of completeness should be included. Okay, so are we ready to bring the jury in, or are there any other?
Sorry, Judge, there's one more issue. Yesterday, there was some questioning regarding opinion from the defense relating to Jason Mingle, and they cited 906.16, bias of witness. And so I guess the state's concern is, yes, the defense can ask a person if they have, bias, but it's limited to any party to the case. And Mr. Mingle's not a party to this action. So I just don't believe that asking opinion related to what a person may think about Jason Mingle is relevant.
Well, at least, I don't know if we're going to go back to argue about that yesterday, but as I understand it, Mr. Nelson was trying to connect Ms. McCandless to Mr. Mangle, and I assume if there's bias against Mr. Mangle, there may be bias against his girlfriend as well. Maybe that was his argument. I don't know. But we didn't get there. We didn't go there because she wasn't aware, that witness wasn't aware. But that's yesterday. That's water over the dam. So.
Sure, Judge, I just wanted to, in case it was brought up, I would be objecting, so I wanted to just let
All right.
you know.
Well, certainly any evidence of bias against Ms. McCandless would be fair territory.
Correct.
Okay. Anything else?
Yes.
Yes.
Because I'm assuming we're going to run through several witnesses quickly, and based on what the state list is and what they asserted and what occurred yesterday, the state is taking the position, I believe, and they should correct me if I'm wrong, that they are entitled to bring out character evidence, opinion or reputation evidence as to whether or not Alex Woodworth was a peaceful person, because the defense raised it in its opening statement. And I do agree that that's actually a fair statement of the law. There's case law on that. However, character evidence for reputation and opinion is extremely limited, and the kinds of questions that were being elicited by the state yesterday were totally improper. And all the state may do in character evidence under 90404 and 90405, which are that the character of victim, which is allowed, the peacefulness of the victim, often by the prosecution in a homicide, to rebut evidence the victim was the first aggressor. So first of all, that's allowed. And second of all, the method of proving character under 90405 is strictly by reputation or opinion, and the statute states, in all cases in which evidence of character or trait of character of a person is admissible, proof may be made by testimony as to reputation or by testimony in the form of opinion. On cross-examination, inquiry is allowable into relevant specific instances of conduct. In State v. Jackson, 2014, Wisconsin 4, which was a first-degree intentional homicide case, there is an extensive discussion about what foundation needs to be laid and what is permissible under 90405. And the Jackson case is very instructive at paragraphs 66, 67, 68, and 72. And in paragraph 72, I'd like to read from that case because it specifically discusses what the foundation is for character evidence that has to be made. The foundation for reputation is deliberately simplistic. Properly framed, the reputation testimony can be elicited in less than a minute. The streamlined foundation befits the evidence modest probative value, citing Blinka, Dan Blinka's treatise on evidence, and I'm sorry, I'm not seeing the actual underlying treatise, but it says a proper foundation for reputation testimony requires showing 4 elements. 1, the witness belonged to or is knowledgeable about a community to which the subject belongs. Number 2, the subject has a reputation for a particular character trait, meaning that it has been the subject of discussion among that community. 3, the witness knows the reputation. And 4, the witness testifies to the reputation. So it's basically a 4-question examination. The court earlier says at page 66, or 66, reputation testimony, and the same is true of opinion testimony, is one form of hearsay in which a witness will testify about the subject's reputation within the community. And then it defines opinion testimony. Opinion testimony permits the witness to testify about his or her own opinion of the subject's character. Neither reputation nor opinion testimony include evidence of specific instances of conduct, except perhaps in cross-examination or rebuttal. Reputation and opinion testimony, the court goes on to say, have significant persuasive limitations before a jury because they tend to be of a sweeping and conclusory nature. Reputation testimony in particular has been aptly but disparagingly described, disparagingly described as, quote, irresponsible product of multiple guesses and gossip, again citing Dan Blinka. This type of reputation evidence does not permit the jury to hear about specific acts. In this case, the counsel for Mr. Jackson, who happened to have been me, was trying to admit some specific acts of conduct to show that the decedent had a reputation for violence. And the court disallowed me from being able to present that evidence because Mr. Jackson didn't know about these things. And the only thing that could be brought in was if the foundation could be laid, would have been these 4 questions. Are you part of a common community, or describe what community you're part of? Has there been talk about his reputation for violence? Does he have a reputation, in this case would have been violence, for them it's peacefulness, and what is do you know the reputation? What is the reputation? So if they want to ask those questions of these witnesses, that's fine, but the questions that were being asked yesterday were much more like, what kind of person is he? So if they want to say, do you have an opinion, lay the foundation, how long they've known Alex Woodworth, do you have an opinion as to his character for peacefulness? And the witness can say, yes, they have an opinion. They can certainly say, what is that opinion? If they can demonstrate that the witnesses have discussed that among each other and that they're part of a common community, then they may ask about what people have discussed, what not specific facts, but what is his reputation. But they cannot go farther than that. It's clearly objectionable.
Let's stop there.
Thank you.
Does the state disagree with that characterization?
Yeah, well, I do and I don't, all right? The problem with that characterization is that the statute specifically allows, if you look at 90405, it allows reputation, it allows opinion to prove character, and it also allows specific acts of conduct or specific instances of conduct to prove reputation. If you look at sub 2 of 90405, it says in cases in which character or trait of a character of a person is an essential element of a charge, claim, or defense, proof may also be made of specific instances of the person's conduct. And it's our position that obviously because of the allegations of the defendant as it relates to Alex, that his peaceful character is a essential element of the claim in this case that the defendant murdered him. And it's made that by the defendant's allegation that, in essence, that he is the initial aggressor. And so, yes, we can prove by specific acts of conduct. And if you look at paragraph 68 of Jackson, it says that's something that the court needs to take a look at and can consider as long as it is part of that. Jackson eventually found out that because of the fact that Jackson was not aware of those conducts and the purpose of the admission of them was solely for McMorris evidence, is what the court looked at it under, and looked at it under the McMorris standard, that those were not admissible in that case. But in this case, we believe that specific instances of conduct showing that he is are certainly admissible in this case. because they tend to show the defendant's character for peacefulness under the circumstances. We also, and certainly counsel is right, we can ask them if they have an opinion. We can ask them how well they know them, and what their opinion is as well. And I believe the specific instances of conduct are admissible because of the fact that it is an essential element of this offense.
Now, how is Mr. Woodworth's character an essential element? There are two elements to first-degree intentional homicide. Element number one, the defendant caused the death of Alex Woodworth. Number two, the defendant did so intentionally. And in fact, a more complete reading of the Jackson case clearly shows that it is not an essential element, reputation or opinion evidence. The specific acts of conduct are in the province of the defense. We can cross-examine these witnesses about specific acts of conduct about Alex Woodworth, but it is not an element of the defense, nor is what they know about his character a specific element to even a lesser included of the defense. The state has the burden here of proving an intentional homicide occurred, or perhaps if lessers are submitted to this jury, and they're certainly being requested, the state has further burdens to disprove Miss McCandless's beliefs and the reasonableness of her beliefs. That's not an essential element, because those things go to her state of mind. What other witnesses say about Mr. Woodworth's character does not go to Miss McCandless's state of mind in any way, shape, or form. So
Well,
they are limited.
Also, I think you're conflating with Morris evidence with the character for peacefulness that's allowed when there's a claim that the victim was the first aggressor. I think they're just different situations. It doesn't matter, in the court's opinion, it doesn't matter whether Ms. McCandless was aware of that instances of peacefulness and so on and so forth. It's just different. And so, I mean, she makes her claim of self-defense based upon, what she will testify to, and the court's allowed quite a bit of latitude, other knowledge of Mr. Woodworth and his writings and other situations and so forth. But that's different. That goes to her state of mind and when exercising what she claims is exercising the privilege of self-defense. This, in the court's opinion, is different. Once a claim is made that Mr. Woodworth was the first aggressor, then I do believe the state is entitled to go forward with both opinion and reputation testimony. Now, in sub 2, the specific instances of conduct, I don't know. Is there anyone aware of any particular authority where this issue has come up? Mr.
I'm sorry?
Are you aware of any particular authority where this type of situation has come up?
I'm not aware of any off the top of my head, Your Honor, no.
I did find something, but quite frankly, it's from 2001 and it's unpublished, so I was not citing it to the court.
It's too old.
It's too old.
Too old for unpublished.
Too old. So I'm not even going to say the name of the case. I was all excited when I read it, but now I'm very unexcited.
Okay.
Judge,
Go ahead.
I might
Mr.
have a case here. Just give me 30 seconds.
Which case?
Judge State v. Evans, 187 Wisconsin, 2nd 66.
You should Joy can get that.
You said Evans?
Evans?
I'm sorry, what was that site again?
EVANS.
Correct, Judge.
That's 187 was 2nd 66.
And this was a case in which the defense was prohibited from bringing in specific instances of conduct in their direct exam of a witness. So while it wasn't the state, it wasn't this reputation for nonviolence, it's the same situation in that it was somebody who was trying to bring in specific instances of conduct as a part of the direct exam of their own witnesses. And the court made rulings based on facts in that case that could not be done on direct. For the reasons in that case. I mean, I don't want to...
Well, let me ask you, is the state have specific instances of conduct that it is intending to offer, or is the state plan to stick with reputation?
Well, I think, I mean, one of the things that we will intend to introduce is through Court Fox, that they had specific discussions about the issue of self-defense, that Alex Woodworth and he, in the context of having observed videos relating to some protesters and counter-protesters where there was some fighting, they had some discussions about the philosophical morality of self-defense, and that Mr. Fox had the opinion that it was okay to use violence in self-defense or defense of others, and that Alex Woodworth expressed that he did not believe that you could use violence in self-defense, but he could potentially see himself using violence in defense of another. So I don't know if that's a specific instance of conduct. I think it goes more towards the basis for Court Fox's opinion to an extent as to why he believes that Alex Woodworth has a peaceful character, but I don't know that's actually a specific instance of conduct.
Right. Well, what about with Ms. Is it Ms. Cobbs?
I'm not aware of any specific instances of conduct. I'll be asking her.
All right. So why don't we do this? Let's get the jury in and take the testimony that we can get, and then we can address that later if the issue of specific instances of conduct are anticipated, but we'll stick to the manner described in Section 90405, subsection 1 for now. Okay? Are you ready with the witness?
So what I hear Your Honor ruling is that they can do it in the four-step process that we've talked about that was outlined in State v. Jackson.
Well, I think that's the reputation part of it. But yeah, reputation or opinion evidence.
An opinion, I understand it's not going to come up with Ms. Cobbs, but with Mr. Fox, he can give his opinion, but he doesn't get to say the basis for his opinion. As Mr. DeFore was just trying to let, he might have that foundation, but he doesn't get to say that hearsay conversation.
We may come back to it. I'm just saying, if we don't have it with this next witness, then let's bring the jury in. Let's have them hear some testimony. Okay.